The evidence of the plaintiff here is the police, the state of New South Wales, believing that it can hold someone as a ward of that state and treat them as guardian to what would now seem to be complete lunacy. What happens when the guardians become the lunatics? That's the question that I have, is now what happens when the guardians become the lunatics? All one can say in that respect is that you shall know them by their fruits. And the fruits of the state of New South Wales are very evident in this document. 104. To the extent that there is material available addressing these mandatory matters, I will refer to it at the level of a detail I consider critical to my determination of this application, given the very short turnaround time period of this judgment. Not every aspect of all of the 1,500 plus pages of material tendered can be subject of reference or comment, and that doesn't include the 2,500 pages and 13 archives of videos that were tendered previous. So we've got 1,500 plus pages now tendered in a interlocutory application, which is a side application to the initial application, which has probably got thousands and thousands more. Section 25(3)(b), assessments of psychiatrists, psychologists or medical practitioners as to the likelihood of the offender committing a serious terrorism offence and his cooperation with assessment. So again, to be tarred with a brush and then be told, hang on, you've already framed me, why should I cooperate any further, becomes a crime. To the extent that there is material available addressing these mandatory matters, at which the police have flooded the court with an overflow of documentation which has turned out to be non-credible and full of conjecture and full of convoluted basic lies. 101. Division 2.4 of the Act sets out the requirements for determination of an application for an extended supervision order. Section 25(1) provides that the court can determine an application by making the order or dismissing the application. We can already say that the application was dismissed. We know this from the bottom of the document and the top of the document. But we start to see why it was dismissed when we look deeper into the inaction, which is then reflective of what action or modus operandi was behind the action. This is important when it starts to become apparent that the state has had a serious issue with an underlying fact of law. 100. Even if the court thought the test was satisfied, the court should decline to make the order on discretionary grounds, given that the role of the CTO and the Commonwealth recognizance that will both run to control any risk presented by the defendant. Control any risk will both run to control, given the role of the CTO and the Commonwealth recognizance that will both run to control. This very, very stark comment. This is a stark statement. Having the ability to control, having a role given under two different branches to control, given a belief, merely over a belief, even if the court thought the test was satisfied. So what the court's saying is that they don't think the test is satisfied. They don't even come close to thinking that it was satisfied. It's so laughable it can't be thought of as even close to being satisfied, even if the court thought the test was satisfied. So the court is taking a very good standing here in recognizing that there is no satisfaction being put forward in relation to a claim that was made.